The topic is the Brown versus the Board of Education decision in Topeka, Kansas, 1954. And we have with us our guest, Attorney Julian Blackshear. Attorney Blackshear, before we so abruptly interrupted you the last time, let's give you an opportunity to talk about the decision that was important in terms of the separation of the races, quote unquote, the Plessy decision. Let's start, give you an opportunity to do that.
Before I talk about that, let me put it in perspective. What I was about to say is the Supreme Court as an institution is not separate and apart from the political system. It's a third branch of federal government. It is an extension of the political system. And it's the whole basis of the Constitution of the United States as prepared and drafted by the founders of this country is that it must be drafted in such broad-based, generalized language that is capable of being interpreted and reinterpreted as society needs for it to say at the time. That's why the Constitution is always a living document. So within that context, the Supreme Court interpreted the Constitution in a manner in which society needed for it to say at the time that it was called upon to say it. So in 1896, 31 years after the Civil War, Supreme Court trying to maintain the integrity of the 14th Amendment that required no discrimination of the races, but at the same time understanding the social chaotic situation that existed at the time, 31 years after the Civil War, said that it's all right to separate the races so long as the facilities that the government provides to both of them are substantially equal. Hopefully that would satisfy the 14th Amendment requirement. Now, in 1954, now the Supreme Court in Brown versus Board of Education completely overruled that. Now, you need to understand, the Supreme Court in 1954 was trying to interpret the rights of the same black people under the same 14th Amendment. Then no I was undotted, no T was uncrossed. In 1896, it said that it's all right to segregate the races so long as the facilities provided to both of them are substantially equal. But this time in 1954, interpreting the same rights of the same people under the same amendment, make a 360-degree turn and say, no, no, no. You now must have integration in order for the 14th Amendment's requirements of no discrimination on the part of the government are satisfied. So you see that what has happened. In 1954, society had changed. It had changed to such a degree that the Supreme Court had to make that Constitution say what society needed for it to say at the time that it was saying it. And that's the reason why you got an entirely different interpretation of the same amendment regarding the same rights of the same people in 54 than what you had in 1896.
Now, then looking at that decision in 1954, and I think you said earlier that that decision was based upon several earlier decisions that eventually overturned it. Talk about the individuals who were involved in terms of the part that they played.
All right. Charlie Houston was the dean of Howard University Law School at the time, and he was the mentor of Thurgood Marshall, a young lawyer, general counsel of the NAACP Legal Defense Fund. And the theory is that what factors are you using to determine whether the facilities provided by the states are substantially equal? Here you had Painter that was trying to go to University of Texas Law School. I mean, Sweat was trying to go to the University of Texas Law School, and they refused to do that because Texas said, well, we got a law school for the colors over there, which we now know to be Texas Southern. Consequently, under the doctrine of separate but equal, so Texas said, we have provided a facility substantially equal to that of University of Texas Law School, so therefore, Sweat, we don't have to allow you to University of Texas Law School. Charlie Houston and Thurgood Marshall both showed to the court that if you use tangible factors to determine the equality of both schools, then what University of Texas Law School is saying is the same thing. So it's correct. You got the same number of trees, Pork chops on Sunday, University of Texas. Pork chops on Sunday in Texas Southern. 10,000 books in the University of Texas. 10,000 books in Texas Southern. But if you use the intangible factors to determine whether facilities are substantially equal, then you see the University of Texas is a much, much more superior law school than Texas Southern. Because University of Texas' reputation was superior to the no reputation that Texas Southern had. When you had a young, vibrant, and energetic law professors at University of Texas, as opposed to law professors who had already spent their 30 and 40 years at Harvard and Yale and so forth, and basically in a retirement situation, and falling asleep in class when they're trying to teach the same kind of subject matter at Texas Southern. So when you see the lack of reputation, the lack of respect of the two different degrees, then you see that in reality, the University of Texas is a much, much more superior law school than Texas Southern, and therefore concluded that Texas had violated the doctrine of separate equal, and Sweat had to be enrolled in University of Texas. That set the battleground for Brown versus Board of Education, because when Charlie Houston and Thurgood Marshall finally persuaded the Supreme Court to accept intangible factors to determine whether or not separate but equal was established, then all they had to do now is find one intangible factor that simply could not be resolved unless you just abolish the doctrine of separate but equal itself. And that is what they found in Brown versus the Board of Education.
1954.
1954.
That was, and that indeed was a...
If it had not been for Sweat versus Painter that established the principle that you look at the intangible factors to determine whether facilities are substantially equal, you would not have ever had a Brown versus Board of Education that found that intangible factor that could not be resolved, could not be solved, unless you just abolish the doctrine of separate equal itself, and by virtue of that, it fell on its own weight.
What was the relationship between, this is last minute before commercial, between Thurgood Marshall and
Charlie Houston. A student and professor. Charlie Houston was the dean of law school at Howard University. Actually, he graduated from white law schools and white undergraduate schools, but he offered his talent and expertise to Howard University. Along with the various young law students and so forth, prepared all the briefs, did all the research, and came up with all the theories. That's the backbone behind that whole decision.
Very good. And of course, we're getting ready, Attorney Blackshear, for our second commercial break. And after we come back, we'll have about 6 minutes. And then we'll give you an opportunity perhaps to say something about segregation as it existed in the southern parts of the United States, because I think that that is one of the things that people generally associate with Brown versus the Board of Education. And of course, we'll be back with our audience following this very, very short commercial break. The topic is